All right, you brought yourself to order. This is very impressive. We're waiting for our member of the panel who's going to participate. Oh, is he here? We have one member that's going to participate by Zoom, and so we're waiting for that. And we'll just give you the sign when that happens. So I'll go ahead. I think this panel is really anxious to get started. So I will turn it over to you, Maya and Mark. And thank you all for being here. Look forward to hearing what you have to say.
Afternoon, folks. It's nice to see you all on this frigid winter day at last. Now to the session that I think is probably best titled Knives Out, because there is real disagreement on the principle here, which is, should non-lawyers own law firms? And I think that this is part of, or a continuation down the spectrum of third-party litigation funding. You get third-party law firm funding. So there are a number of different components to it. And we have a distinguished panel. On the pro non-lawyer ownership side, we have Adrian Chopin, who I think you can see, who is in London.
Hello.
And we have Charlie Platt, who is here, not in London. On the anti-non-lawyership law firm ownership side, we have Steve Younger of Nixon Peabody and Sherry Wallach, Deputy Executive Director of the Legal Aid Society of Westchester County, both of whom are past presidents of the New York State Bar Association.
I think Sherry's still the president.
Oh, I'm sorry. Yeah, I apologize.
Is this January 6th?
No. We're not storming the Bar Association at all. So to kick this off, we're going to start with the pro non-lawyer ownership side. And Adrian, you're up. Thank you.
Hi. Thanks, Mark. I thought what I would do is talk a little bit about the nature of non-lawyer ownership and how widespread the phenomenon is, and the profile of the typical party who comes looking for that non-lawyer financing, before we dig into the knife fight of pros and cons. So I'm the managing director of Benchwalk. We're about $1 billion assets under management litigation funder. Our primary offices are in New York and in London. We launched about 5 years ago, and in that time we have executed sort of 2 true equity ownership transactions in respect of law firms, where we provided startup capital and ended up owning effectively equity, and a much larger number of portfolio transactions or law firm financing transactions. This debate strays across both of those lines, you know, whether you're providing law firm financing on a limited recourse or full recourse basis, and into the true equity ownership transactions. I mostly want to talk about the true equity ownership transactions, just on the basis that those, I think, are harder. But they sort of make it easier for opponents of outside ownership to make their arguments. So I'm going to stick with those. We've only actually executed 2. We've looked at a large number more. The UK changed the law to permit external ownership relatively recently, and the legislation was enacted some time ago, but really you know, the enabling legislation took a number of years longer. But I think in the last 5-6 years, we probably saw 2 or 3 law firms looking for startup capital in return for an equity stake. And in the last year, we've probably seen 10. So there's definitely a growing trend, but it's not a flood by any means. What's the profile of the typical lawyer looking to borrow capital in return for an equity stake? It tends to be partners in their 30s or 40s who have run a relatively successful business within a larger institution, but have decided, I want to try something different, and perhaps I want to own the business and be a little bit more master of my own destiny. Yeah, and quite often it's lawyers who want to try a different fee model. So frequently they're coming out of Magic Circle or White Shoe firms or equivalent in other jurisdictions and have seen the hourly rate model and want to try something different. I think that leads me on to one of the key reasons why external capital is useful. First, because some of these people simply wouldn't be able to launch these new firms without external capital. They haven't yet saved up enough of a war chest to be able to launch their own businesses. But secondly, because it enables that creative destruction that makes most other industries thrive. And law has been an outlier for centuries. But that creative destruction manifests itself in a number of ways, but one of them is that a lot of these new law firms are trying alternative fee structures. So I know my clients don't like a standard hourly rate structure. They'd like a fixed fee arrangement or more success fees or something entirely new altogether. And those arrangements often require somebody to cover the working capital of the firm. And that's the third party funder in our case. So it's not yet a flood, perhaps it will be. It's being done cautiously and responsibly at the moment. It is enabling some really entrepreneurial ideas. Some of them will fail, but I think that's the nature of the creative destruction on which capitalism flourishes. So with that, I will end my opening remarks and hand back to Mark.
Thank you very much. And our next speaker is Charlie.
Can I stand up?
You may.
May it please the court.
And by the way, for all the panelists, David in the back is keeping time for us.
So the red light will go on. Hi, I'm Charlie Platt. I'm the CEO of a company called Cartiga. Cartiga is in the business not only of providing funding to law firms and their clients, both what we call commercial funding and consumer funding, but it's also in the business of providing data analytics and technology that will enhance that use of capital. And before I joined Cartiga, I was a practicing lawyer for many years. I litigated and tried cases both on the plaintiff side and on the defendant side. So I totally get the need for care when we're talking about changing the rules of professional responsibility, at least in this country, to switch to a non-lawyer ownership structure. But at the same time, I found myself becoming a very strong proponent of non-lawyer ownership based on what I've learned at Cartiga. And so I thought I'd talk initially just a little bit about what we're thinking about at Cartiga, and then talk about what some of the reasons are for thinking that the change is really inevitable if we're right about what we're thinking about at Cartiga, and then talk about why maybe some of the concerns about non-lawyer ownership I don't think are as well-founded as maybe some of the opponents think. Cartiga thinks that law firms can be much more efficient and much more transparent in civil litigation if they use data analytics and technology and capital more effectively. And we think they can do that more effectively through a non-lawyer ownership structure. And when I talk about law firms being more efficient using data and data analytics, I talk about whether or not lawyers can start determining very early on in the case what's the optimal value that can be achieved in a case based on pools of data showing ranges of outcomes. What are the key variables that will drive those outcomes? How soon can the optimal value be achieved? And what is the durational risk of not achieving an optimal outcome in a shorter period of time? And then what are the fixed and variable costs that will be incurred in trying to reach that optimal outcome? So that's efficiency. And then also on transparency, we think that the consumer and the client can greatly benefit if the legal process is more transparent, if law firms are more transparent. So how can we do that? By using data analytics. Again, we can start to tell people about the range of potential outcomes in their cases. We can talk to them about how long it's going to take for them to get that outcome. And also, what are the resources required to achieve that outcome? And how does that relate to the price that they are paying for the legal services? I think these are really attainable goals, just based on the work that we're doing. Cartiga and other companies we know, our competitors, are already creating those types of data analytical tools for law firms. But we also can look at the rest of the country, and most every business in this country is now using data and data analytics and technology and capital to become much more efficient. They're driving down their unit costs, they're raising their productivity, they're expanding consumer access to services, and perhaps most importantly, they're providing a lot more information to consumers about what the service being provided is and why the cost is where it is. Now, even though I think these are attainable goals, I think it's quite clear that the legal profession is way, way, way behind the rest of business on this particular subject. And I think that could be for a number of reasons, but one of the reasons I'm familiar with is that law firms are used to making judgments on their cases based on their own personal experience, based on their own personal expertise. They don't have pools of data that they routinely look at to inform that judgment. And I equate that to effectively using dead reckoning when you're piloting a boat instead of using a sophisticated GPS system that is available. Now, I should say to all the great legal minds in this audience that, of course, all of you out there in this particular audience have algorithmic minds that probably don't need data, but we have to think about all the other lawyers out there who aren't quite as fortunate as the great minds in this legal room when we're talking about this particular issue. So I also think that even if lawyers are innovative, even if they are open-minded, like Adrian says, the profile is the 30 or 40-year-old who's more inclined to be using data analytics, more inclined to be using technology, they're not investing in and using data analytics and technology. And nobody really knows why, but I think it's quite clear that because they are not using it, because they're falling further and further behind, we have to adopt structures that will permit them to do that. And I think a non-lawyer ownership structure is the way to do it. And I think that's for two reasons. One, because if in fact lawyers can start sharing the equity in their success with finance professionals, they'll get better and cheaper access to capital. And capital, as anybody who runs a business knows, is critical in trying to innovate and trying to do some new things. And I think if lawyers can share equity with other people, they can start to attract people who are technology and data professionals, and they will help spur the use of data and data analytics. So if we can start getting these non-lawyer ownership structures, and we can start getting these finance professionals, these data and analytics professionals involved, we can start gathering pools of data of case outcomes and variables. We can start measuring whether or not we're achieving good results in shorter periods of time. And we can start using data to provide clients with more transparency. I'm not saying, by the way, that this is a solution for every case or for every law firm. And I'm not saying that every law firm should rush out and immediately start doing this. What I am saying is for many routine cases, non-lawyer ownership can bring this these benefits to law firms in general in civil litigation. And on fiduciary duties that are owed to clients, I think we can address, I'm running out of time and the red light is on, but I think we can address those by looking at whether or not these technical advances, this data analytics, are actually improving service to the client as opposed to running into professional responsibility concerns. Thank you.
Thank you very much. And now we want to do a quick survey of the contrary views, and we'll start with Steve Younger.
Thank you. It's great to be back in my old neighborhood. I guess that I'm the only person who's here who's not selling anything except the core values of our profession. And I want to distinguish, we talked a lot about litigation finance. As Charlie knows, we've worked together a lot on litigation finance. I'm a huge believer, but it's not non-lawyer ownership. Litigation finance, Charlie can't tell me how to run my case, and he won't. He'll stay away from it. That's the problem. So where are we? Why are lawyers overwhelmingly against non-lawyer ownership in the United States? We'll talk about it across the pond. Every bar association in this country, except perhaps DC, only a little bit, and Utah and Arizona, is against non-lawyer ownership. New York, California, Florida, Illinois, Ohio, and last summer, as you'll hear from Sherry, the ABA reaffirmed its decades and decades long opposition. Why is that? Because we're professionals. We have independent duties. We owe duties to our clients, not to businesses, and I have nothing against businesses. I work with them all the time. But nobody who's not a lawyer is entitled to second guess my independent judgment, except my client, who has a constitutional right to do stupid things. I do them all the time. But that is why, and I encourage you, I have extra copies up here for anybody who wants it, to look at the New York State Bar's report on this subject. Extra copies, 78%. What lawyers agree on 78% on anything of lawyers, in-house counsel, out-house counsel, they're out-house, you know, small, large, everybody, 78% of lawyers are against. Why is that? For me, we all know law is a business, but it's that red line when somebody else is telling us what to do, who's not a lawyer, who doesn't understand the obligations we have. It's a second, consumer harm. Look at what's going on in Arizona. Number one is wealth managers. I wish my poor clients needed, when I do pro bono, needed wealth managers. They're joining up with insurance salesmen, okay? You want to find every trust and estates plan with an insurance policy? Joint venture with an insurance person. I have my own situation, my glasses. I thought I was going to a doctor with ZocDocs, and I ended up at an optician selling me the most expensive glasses I've ever owned. This was a month ago, and they fell apart, okay? Those are the problems you have, but even more. It's gonna be in the news in a day or two. There is a $300 million fraud claim out of an ABS in Arizona who is doing business in Florida illegally. And there are two bar complaints, one in Arizona and one in Florida. This will be in Bloomberg Law in a week. Why? Because you have people who aren't lawyers running the show. But what are we for in New York? We're for access to justice. And our report said, if you can show us that non-lawyer ownership promotes access to justice, we're all in. In fact, we're actually doing it in New York. We have our Navigator program, which provides, non-lawyers to help people in courts under proper supervision. We have our LIFT program, which provides forms. We need to do more of that. But that's not what's going on in either Utah or Arizona. It's basically shifting the profits of the legal system to non-lawyer owners. So the last thing I just want to touch upon, because I totally agree with Charlie on this, we need to innovate. And the mantra is, because of non-lawyer ownership, only non-lawyers can innovate. I mean, that is an insult to every lawyer in America. And everything that Charlie has said, we're doing already. I use it every day of the week. Every day of the week, I use data because I know that if I just say that I sat in front of Charlie's father and I really liked the Eastern District, but when I was in Texas, they were mean to me, that's not a great way to decide on venue. I want to get the data, and we're all doing that. But it's really a mistake to say we need to give over the keys to our profession just because there are lawyers who don't innovate, okay? So let me just close with this. Lawyers across our country, no matter how you slice it, do not want this because we don't want to have somebody at the end of the year say, why haven't you settled that case? We need to bring dollars in. Now, we have that going on anyway, but we don't want to put somebody who owns us saying you have to, okay? And that's the fundamental difference between non-lawyer ownership and litigation finance, where that person has purse strings, but takes real caution about exercising their independent judgment versus mine. And with that, I'd like to have our president, Sherry Wallach, talk about what happened in the ABA last summer. And I do have extra copies of these if you want. Otherwise, they'll be sitting in my office.
Good afternoon, everyone. So Steve's my handler. We joke about this. He told me what I'm going to be talking about. I'm going to go a little bit beyond what he suggested. I'm not only going to talk about the ABA. Let me start by saying this. Law is a profession. It's a profession that we respect and that we are honored to be a part of. We cannot dilute that profession. We have responsibilities. We are held to a code of ethics. We are held to certain standards as lawyers. And our counterparts who are not lawyers, who are investors, funders, many of whom I know are in this room, and I'm going to take a survey in just a moment, are not held to those same ethical standards, to no fault of theirs. But that is the impact. And that is what we have to think about when we think about how we are going to handle this. Are we going to dilute the profession of law? And are we going to restrict the ability of lawyers to do what they have to do as professionals in representing their clients? And I suggest that if we enter down the path, as some states, as Steve mentioned, have, into non-lawyer ownership, we are doing just that. Because now as lawyers, we are being told how to handle a case based on finances, based on the financial outcome for an organization and not based on the best interests of the clients. And for those of you who are still practicing, starting to practice or do practice, you know, we must put our clients first. We are bound to. So let's talk about this for a minute. When we think about some of the things that have happened already, I look at this and I akin this to what happened to the medical profession. How many of you here remember what it used to be like when you went to the doctor and you needed an operation and you were sent to the hospital and you were given that surgery because your doctor recommended it? Now, how many of you in this room have either yourselves or known people who have been recommended for surgery, but told now, sorry, you can't get that surgery until you do 3 months of physical therapy because the insurance company won't pay for it? So let's think about this, and let's think about this in the context of non-lawyer ownership. If we think about it in the context of non-lawyer ownership, the arguments are that it's going to move cases. But how is it going to move cases? When in fact, what it's going to do potentially is delay cases based on the best resources that are, the best use of resources that a firm might have. For example, a non-lawyer partner in a firm may say to a lawyer, I'm sorry, we can't fund that trial right now. We don't have the money for that expert. As a result, you really should consider settling. Or maybe you should take an adjournment. And now all of a sudden, what have we done? We've slown I don't know what that means, David, but thank you. Okay. We've slowed the tracks of justice down, in fact, right? We've delayed justice because now these cases are being delayed based on economic decisions, not on decisions that are the best interest of a client. So let's talk about Model Rule 5.4. How many of you in here are familiar with Model Rule 5.4? Anyone? Oh, look at that. Well, okay, so that's my homework for you. You all need to go and read Rule 5.4 of the Code of Professional Ethics that was put forth by the ABA. Because in Rule 5.4, it says very clearly that a lawyer shall not practice with or in the form of professional corporation or association authorized to practice law for profit. It also says that a lawyer cannot receive profit from partnering with a non-lawyer. That's Rule 5.4. And I'm obviously summarizing quite a bit. I suggest you read it. The point is this: the discussion has now turned to changing the Code of Professional Responsibility to accommodate this new form of ownership for profit, not for the profession. So go read Rule 5.4, because that was at the crux of the discussion and the debate that took place in the ABA, what Steve referenced, and I'm looking at my time, what Steve referenced regarding the resolution that was passed, or I should say reaffirmed, which was Resolution 402. You can look that up too at the ABA. And that reaffirmed the stance against non-lawyer ownership, in particular to avoid these ethical complications that are put forth and upon lawyers when they enter into these relationships. So a couple just quick points, and Maya, you tell me when I need to leave and I will. But I just want to reference in an article that I wrote that was published in Bloomberg not too long ago, some of the things that we needed to address. And some of those things include access to justice. There's an argument that's going to increase access to justice. You tell me, those of you who are aware of the access to justice, the gap is in representation in court. It is not in non-lawyers helping people outside of the courtroom. It's an actual representation, and only lawyers can do that. As Steve referenced, in New York, we have the Court Navigator program. That is a very successful program that helps clients navigate the system, but stop short on giving legal advice. And then I just want to point this out because I know I'm running out of time. Very quickly, if you look at the models in Utah and Arizona that we are talking about today, and we will talk more about today, where they've engaged in non-lawyer ownership, there has been no research whatsoever of client satisfaction or client outcomes, or if clients were given the correct advice by the non-lawyers. I'm sorry, the non-lawyer owned firms and the non-lawyers. And that's really important. There is no data yet on that. And there won't be, I guarantee you, for years to come, because the implications are far reaching. I know I'm out. I'm sorry. I will end on this point as I'm being hooked off the stage. But the point that I want to raise is this. When you think about this from the implications of the non-lawyer ownership, it far reaches into estate planning issues and things that we may not know about because somebody was given advice on uncontested divorce that ultimately impacts their estate plan down the line. And we don't know that now, and we won't know that for years to come. So I leave you with those thoughts, and thank you.
Thank you very much. And what we're going to do now is I and Mark will direct some questions to our panelists just to get a discussion going, and then we'll open it up to Q&A, which we're sure that the audience has. So I want to ask Steve and Sherry in particular. The debate now is happening in a different environment than it has been taking place pretty much every decade for at least a century. Namely, we're now not in a world where we're comparing law firm ownership to sort of a pristine, no third-party funding and intervention. We're in a world where there's portfolio funding, there's law firm loans that are secured by the proceeds of litigation or by the personal assets of the lawyers. So wouldn't it be better if we just had normalized corporate finance for law firms rather than those forms of finance?
Yeah, I think the environment we're working in is much different. And I think what litigation funding does is it's no different really than the contingent fee. It's just that it's shifted out of, the risk has been shifted out somewhere else. And it was being done anyway, okay? So mass class actions, tort cases, a small law firm could not carry that capital. And I think it's just been more formalized. And I think that the difference between debt and equity is enormous. So when you have a situation where $500 million has been raised in a securitization to fund one of the biggest tort cases in the world, that funder is not going to come in and say, you have to settle Mrs. Jones's case, okay? That's the difference between debt and equity. I don't know many law firms that are holding up signs saying, I need equity partners because I can't raise money. There's lots of money out there for lawyers. Now, my friend in London pointed out one thing. I think there's one group of people who's for this. There are people in some major law firms. I just did this. I was 35 years at one firm. I got my capital back. If I was a partner at Sullivan and Cromwell, I could be like a Goldman partner. I could put that on the market and make hundreds of millions of dollars. Look at what Goldman is today as compared to when they were a partnership. I don't think that's what we want. I don't think we want the publicly traded New York law firm who has all kinds of influences like managing to a quarterly report. That's an entirely different thing than being a lawyer, because lawyers have to manage the two things. What are their clients' desires and what are their ethical responsibilities?
Wait, Steve, do you really believe that lawyers don't manage to economics?
Oh, they do. Of course they do. But how many lawyers sit there and say, Mrs. Jones, I'm going to make you settle this case unless they're withdrawing, unless there's somehow they've got an issue. And usually they're smart enough to say, Mr. Mediator, can we go in the back? We got to negotiate my fee. And they'll very often cut their fee. I'm not denying economics is a huge, huge part of the law world and much huger today. But what I'm saying is it's different when someone's sitting in my firm who now holds the keys to my castle and says, I own 51% of you,
Oh, well,
51% of you, and I'm not a lawyer.
But wait, and I want to add, I think my mic is on, but I want to add something about this that's
Sure.
important to you. Thank you, to your point as well, Mark, and it's this. In the end, it's the lawyer who makes the decision.
oh,
And they are
it's the client
bound,
who makes the decision.
well, sorry, it's the
About
client who
the-
makes the decision, but the lawyer is the one who's, when I'm talking about versus a funder, okay? And hold on for a second. In the end, it's the lawyer who's bound by the professional code of ethics, right?
And would be in any event, even if the firm were owned outright.
Exactly. I
Well,
think that's
let's,
where the-
but let's talk about that for a minute.
That's what happened in Florida. That's why we have a bar complaint in
Okay,
Florida,
okay.
because the lawyer got thrown under the bus for $500 million
And
by the
that's
funder.
gross.
okay?
See what happened?
Let's let Sherry
Let
please
me-
complete
let
her
me-
comments.
Let me comment on that because that's exactly the point, actually, is what you're talking about there is when a non-lawyer makes a decision or influences a lawyer to make a decision and it's the wrong decision, the lawyer is disbarred. The non-lawyer moves on, finds
Never be
another lawyer to
disbarred.
partner with and goes on. So the lawyer loses their entire ability to maintain their profession, to maintain their livelihood, and the non-lawyer partner goes on to another person.
Do you have any evidence that indicates that an outside financier would be able to exert that kind of influence? Because I don't think.
Well,
that is-
Okay, I should be,
Let's just start from the basic premise, all right, that in Arizona, under the alternative business structure rule that Steve referred to, the outside investors are not permitted to engage in the day-to-day practice of law, and they must observe that Arizona lawyers who can practice in day-to-day litigation matters, they must be making the decisions about whether to settle a case and what's in the client's best interest and so forth. And if those rules are violated, the structure will be shut down. Okay, and investors won't want that because
let me
they'll
respond.
lose their investment. So let's start from the premise that we're not talking about non-lawyers making decisions in the day-to-day practice of law. We're not talking about non-lawyers making decisions about whether cases to get settled or not. We're talking about whether or not lawyers should have access to capital and access to data and tech professionals who can improve the practice of law so that people
but
make
that-
better
that-
decisions
that's
for their
completely
clients,
incorrect.
so they can be more of a fiduciary.
I can
than
get
they
you
are.
access to 5 different databases. We all have them, whether it's Reuters, whether it's Westlaw. It's not about data. It's about ownership. Can I finish? It's about ownership.
Steve, Reuters and Lexis are 50 years old.
No, I
We're
can
talking
get you.
about modern data.
I'm
and
getting,
modern-
you haven't looked at Lexis recently. I could do a 50-state survey today of how long it takes to get a preliminary injunction decided tomorrow. And I do it. I do it every day. That's what we're talking. We're talking about ownership, okay? Now, in Florida, there were lawyers who had their clients' money stolen because of a non-lawyer ownership to the tunes of hundreds of millions of dollars. That's case number 1. Case number 2, the average situation in Arizona has nothing to do with access to justice. It has to do with rich people who are now being advised, not just by a trust and estates lawyer, but by an investment advisor, by an insurance agent. And I can tell you from my T&E friends, all you have to do is ask any of your trust and estates friends, when you have ownership, as opposed to I use my usual insurance broker, every one of those cases, 1 has an insurance policy in it, and 2, now the investments get run in a way that is not the way a distinguished trust and estates practitioner would. And I can give you 4 more examples if you want. There's one in Utah where a robot is advising people, okay? And you love when you call Delta Airlines, you can't get a person, and they tell you that your flight is leaving tomorrow when everybody knows it's not.
We've stipulated that we're not here arguing for robots to be advised.
But that's being done in
We're
Utah. It's
talking-
being done in Utah.
Steve, we're talking about not.
I'll have chatbot advise my clients from now on.
Steve, let's have a debate. instead.
All right, excuse me,
Okay.
guys.
As
I'm
the
in the middle.
moderator,
Since
as
I'm
the
in the middle.
moderator, I want to make sure we cover at least one more topic before we open it up to the audiences and
Guns at the night.
it's all friendly. We're all friends.
Charlie,
No
they're
gun
really
knife
good friends.
technologies.
I just said I'm right.
My question to to all members of the sitting panel, and I
By the way,
want
this is all in my Yale
Uh,
Smart Journal
Steve.
article. if you want.
I want to make sure that we let Adrian take a stab at this first. I can't see him, but Adrian, if you can hear me out there in the ether, you get the first opportunity to answer this. I think one practical question people want to know is whether the fact that there's now at least one, arguably more jurisdictions, namely Arizona, possibly Utah as well, where it's possible for non-lawyers to own or co-own a law firm.
Definitely.
Does that open up structures that enable ownership of affiliates in other states? How does this, if at all, affect what happens in other states? So Adrian, the floor is yours first.
Thank you. Look, I mean, there's been a lot said in answer to the prior question. I've got to pick on some of it because there are so many factual and logical errors in some of what's been put forward that I'm not quite sure where to begin. I think Mark made the point that no one's advocating for non-lawyers to be litigating cases or providing advice. We're talking about a provision of capital by third parties. Now, what I think the proponents of a ban, so just to actually to part ranks with Charles, I don't think we help ourselves by arguing, yeah, this or that feature is the reason to argue for third-party capital. I come at this from the common law tradition of I can do what I want unless I'm harming somebody else. And so it's for the banners to justify why it should be banned, not for us to make the case on the basis of access to data or access to justice or anything else. It's for those who want to ban it to make the argument. I don't think that argument's been made very articulately. I think a better argument would be the provision of third-party capital has a greater risk of corrupting incentives of lawyers. I think that's sort of the point that the proponents of a ban have been dancing around. But in response to that, I would like to know what structure is it that the third party could impose that is worse than a structure lawyers can already and do already impose on themselves. Just to take one example, for decades, we've had serious objections to lawyers taking any of their fees at risk being remunerated on the basis of success in the case. The UK was much slower to adopt alternative fee arrangements than the US, so we've had more recent experience. But there have been constant objections that success fees of one kind or another corrupt lawyers' incentives. Fortunately, that argument appears to have been put to bed, but I don't see that there's any more merit in the argument about third-party capital being vested in law firm as a corrupter of incentives than contingent fees or any kind of success fee. And in fact, I think there's nothing more corrupting than a standard hourly rate model, because that you get paid win, lose or draw as long as the case keeps going on. So it seems to me that actually the argument from corrupting incentives is not borne out merely by the provision of third-party capital, not least of all because any structure a third party can put in place in terms of remuneration can also be put in place by lawyers themselves. Sorry, those are some remarks on the prior question. I mean, in terms of how can this be structured so that, you know, you might use a fifth column. We might use Arizona to then start co-counseling on cases in other states where non-law ownership isn't permitted. First, I'm not familiar with every state's rules, but I'm pretty sure there will be some fairly robust look-through provisions to ensure that isn't being done. But secondly, I think it's more interesting to have the argument on the principle rather than the specific mechanics of which states do and don't work. And what I can say is if third-party capital is allowed within the rules to provide financing to law firms, it will do so, and it will be healthy because we will unleash some creative destruction in a market that hasn't seen enough of it.
If I could just respond briefly, I think this is the major divide between the UK and the US. We've had the contingent fee forever. You've not. The contingent fee aligns the client and the lawyer. And that's, I think, why we have so much litigation finance, because in almost every finance deal I've done, there's been some contingent nature. I agree with you that the traditional hourly rate made no sense. It's like if you wanted me to build your house and I told you, I have no idea how long it's going to take, but the longer it's going to take, It's going to cost more. That's not the hourly rate in the world I live in. We are much more managed in terms of how we do our budgeting, our billing. And it's a much different world than just saying, here's an hourly rate, go just, do with it without regard to the client.
So so now you guys know why I was sat in the position that I was sat, to separate these two. But, may calmer heads prevail. A couple points I want to make, going back for a minute, and I think this largely stems from this innovation discussion. And when we talk about fees as well, we think about it from that way. So to say that the current fee structure is untenable or doesn't make sense, and therefore we need to bring in non-lawyers doesn't make a lot of sense either. The argument is within the profession, maybe we should be re-examining, as Steve mentioned, the way the fees are used and the fee structure that's used and what is acceptable under our code of ethics. To go back to a point though that was raised, and then I'm going to get next to your point, Maya, because it's related, but the point that was raised about, okay, so in Arizona, you have a non-lawyer who's told they can't make decisions on the handling and the matters of the case, that's the lawyer's purview. Yeah, that sounds good on paper, but does that really happen? And if you have somebody who's holding your purse strings and telling you what the bank account looks like, how is that going to be influencing potentially? And oh, maybe they don't want to be an investor in your firm anymore. Maybe they're going to sell out their share or leave because you are not producing to the level that they anticipated. These are all questions and concerns, but in the end, it's the lawyer who again is disbarred or held to the code of professional standards. So if there's any allegation that that lawyer was in some way guided by the non-lawyer's desires with the case, it's the lawyer who loses. Again, the non-lawyer has no recourse whatsoever. So I would suggest that before we even go any further down this road, what we need to think about is the ethics behind that and the regulations behind that. And to your point, Maya, because it goes right into that, is how do we manage this across state lines, right? How do we manage it? Well, if you look at the case that Steve referenced out of Florida, that Florida lawyer left the firm because he knew that the firm was being funded and managed by a Arizona firm that was owned by non-lawyers. And he knew that that created ethical implications for him. So in addition to all the others, the losses and so forth, that was part of that lawyer's decision. And that led to, again, some of the bar complaints. So to answer Maya's question, right now, there's we have to look at that. It's the lawyers who are held to the level in the code of professional responsibility. But we need to think about this. How do we regulate? What is the regulation? And I'm just going to suggest for all the funders in the room, you're probably saying, don't regulate me. Don't give me a code of professional conduct to follow, because I don't want that. That doesn't work with the capitalistic nature of what I'm trying to accomplish. But the fact of the matter is, how can you have one party regulated so strongly with such severe ramifications as a result of this decision, and the other party just scot-free?
So just on that, why is that any different from auditors, surveyors, bankers, accountants?
Oh, huge difference. In
Doctors,
fact, we had something in
all of them
America
are
called
regulated.
Enron. And there are now, let me ask the question. There are now partnerships between lawyers and accountants in Arizona. Just imagine the next Enron where both the lawyer and the accountant. We had something called Sarbanes-Oxley. I know Charlie's very familiar with this. And many of the accounting firms spun off those other services because they wanted them elsewhere. That's what we're inviting to do in Arizona.
Okay, so before I will open it up in a second to the audience for your questions, probably just as he did. I do want to mention that what Arizona actually has done is that it replaced Rule 5.4, the fee sharing prohibition, with an extremely robust regulatory regime that part of it is extending the ethical obligations of lawyers onto anyone who has an economic interest holder.
But they
Right,
can't
so
be
there is,
Can I-
they cannot be
can I
disbarred.
speak to that
Quickly, and then
Just
we'll
very
open it up.
quickly, because that's
Yeah.
a good point that you raised, and that's one of the biggest debates right now in the ABA and beyond. And in fact, I just received notice that they're having a discussion about this. 5.4 and modifications to 5.4. Should we be modifying Rule 5.4 is one of the things that's out there now. And to that point, what Arizona has done arguably violates 5.4, and that's the discussion.
it.
So, yeah.
Yeah, they abolished.
Yeah.
But thank you. Let's open it to the audience. And let's start with Professor Seebach.
So. Good tries ask questions that different direction. What I find striking about the discussion that's being held so far is this characterization of the protection for the client being based on the judgment of a lawyer. But I want to point out that actually for a lot of the entities that are interested in changing 5.4A, and for a lot, I think of the sort of benefits, not to access to justice. I think I totally agree with Adrian. This is not necessarily about access to justice, but a lot of benefits that otherwise would flow from it. It has to do with the part of the bar that's not solo practitioners. It has to do with the part of the bar that is multi-member firms. And I want to stress that as with medicine, it's a mistake when you're talking about increasing medical safety to focus on single medical providers, but to focus on systems. We also should ask the question, how can we change 5.4A in a way that protects clients by focusing on firms, not on lawyers? So for example, disbarment is yes, lawyers can be disbarred. It's very hard to disbar a lawyer. I mean, I teach professional responsibility in New York State. I know this better than anyone. Just see how difficult it is to disbar John East. Okay, it's very, very difficult to disbar a lawyer. Discipline, however, can be meted out in forms of suspensions, in forms of other disciplinary sanctions that are less than disbarment. Those can be shared by a firm. New Jersey and New York already have provisions for firm-wide discipline. I don't understand why, for example, without necessarily going all the way to Arizona, why it would not be adequate to say to the non-lawyer partner, you're not practicing law, but if you have capital in an entity where a lawyer is practicing law and the entity is discovered to have acted in a way that violates the rules of professional responsibility, the entire entity suffers. I suspect you'd have a lot of additional protections in place that might cover the ground that you guys are worried about.
Yeah, that's what Arizona did, just so everybody knows.
They'll shut
Yeah.
you down in Arizona.
Yeah, but
And-
the problem is they never shut anybody down.
Let's let Charlie
Okay,
take the
but
question.
If you could just give me
Yeah,
a
no,
second.
I'm just gonna,
Thank
because
you.
I think we'll agree with this, except on your.
Tony's point is a good one.
Yeah.
That maybe we should be talking about the impact on a law firm. If a law firm misbehaves in Arizona, whether it's run by lawyers or run by non-lawyers, the implications are they shut down the law firm, right? And that is much more painful to a set of investors than being disbarred. So they have tremendous economic incentives not to let that happen and to observe the laws in Arizona.
Yeah, but can I have this, just so you understand what we're talking about? What London did was they went to firm-wide regulation. We don't have that here. We have that for securities brokers. I know Charlie knows a lot about that. The only place we have firm-wide regulation now is Arizona. I don't think anybody's saying we're against that. I think to some extent there is, because a lot of times if my partner's on the hook, I'm on the hook, but there's no formal way to do that. You can't do in re law firm X. And I think that's a very, very good point. The problem is, as we know in the securities business, it doesn't prevent bad brokerage firms. They're bad brokerage firms all the time.
And they're
It
bad
gives you-
lawyers as
And they're
well.
bad lawyers
No
too.
question.
So don't demean a whole profession, but can I just finish? Because I think you have a very good thought in terms of how you improve regulation. Doesn't mean you have non-lawyer ownership.
Let me stop you for 1 second. Can we put the chart up on the screen? Last August, Bloomberg Law had an article about California and they put together a chart of all 50 states
Yeah, I think the chart
and they color coded them.
Yeah.
Yeah, it's old.
It's old and it's inaccurate.
It's not that old. It's August of last.
Yeah, it was
year.
inaccurate when it was published. So just, so you know, in California, 75% of all lawyers, when they put it out, opposed it, and that's why it's not happening in California. And there are states that say, like they say, New York is considering it. New York is dead set against it. I've read this chart. It's not correct.
Steve,
I believe in data.
can I just respond to that 75% of lawyers? If you're a member of a guild, obviously you're going to vote for continuation of the guild. What we're talking about here is the fact that law firms, at least in the experience that I've been having over the last 3 years, where we're dealing with hundreds of firms are not keeping up. They're not innovating with data and tech. And the way to solve that problem is not to say lawyers can oppose any changes in the rules. The way to solve that problem is to introduce capital, introduce tech professionals, introduce data professionals to law firms and get them to start innovating so that they can keep up with
So
Okay,
every
we're-
other business
so
in
I-
the United States.
I'd like, I
Well,
just wanted to respond to that.
Quick response and then we'll take
Okay.
another question.
So I just wanted to respond to both of those things. Also with the Arizona model and the firm model, which I agree is one way, but I don't feel like it fully solves the problem. Because again, if the firm is shut down, the lawyer's the one who ends up with the mark on them, not the non-lawyer. And so we have to remember that. But going to what you said for a minute, Charlie, and this is really important, is the innovation aspect of it. The fact that you're suggesting, or it's being suggested, that lawyers don't move fast enough in technology and innovation, and we know from our court system that's even been a problem, right? I mean, it took a long time to get us to where we are, but we could move fast when we had to move fast. And that's something we have to remember, because look what happened during the pandemic. When we were forced to move fast, we did move fast, right? And we went to virtual and did all these things. So the idea that lawyers can't innovate and need outside investor to do it doesn't make a whole lot of sense. We can innovate. We know how to innovate. We're just bound by different restrictions that slow us down. So if the idea is to allow for more innovation and encourage more innovation, and I can say this as the president of the Bar Association, that's some of the things the bar associations across the country and the world are looking at. And I'm going to Barcelona next week, to talk on a panel about access to justice internationally and some of these ways to innovate and expand. So I think that we have to remember that we are an innovative profession and we can be innovative within ourselves. Sorry, Maya.
No. Thank you very much. And we have a question here.
The question has to do with data relating to something that some take for granted. And then if I may, a comment on access to justice. If we are looking at two scenarios, factual scenarios that have been posed, a question of whether to settle and a question of whether to hire an expensive expert witness, is there any evidence that the client is better served or worse served in the one model or the other model? Because it's quite possible, isn't it, that where there's non-lawyer ownership of the firm, and there are good lawyers and bad lawyers, and there are good funders and bad funders, it's quite possible that the best decision for the client would be made by the funder and not by the lawyer, with everyone having good intentions. In the question of whether to settle, it's quite possible that the better decision will be made by the funder. So what I'm asking, since we all agree that data is important, is rather than assuming that the funders sort of are bad guys and the lawyers are good guys, and I'm very, very proud to be a member of the bar and cherish the highest ideals of the bar as much as anyone, former law school dean. I don't know why we make the assumption that the funders would make worse or less ethical decisions than lawyers. I've certainly seen lawyers make tremendously questionable and decisions around when to settle, and tremendously questionable decisions about whether to retain experts. That's one thing. And the second thing is, can we require funders
Because I think you're
to
arguing
fund?
credit.
pro bono?
That's not
It's a
what you're saying.
question. It's not an argument. It's a question.
Can I,
I think we
Let's-
agree. We agree
can I
that
field the
funders,
first
I use
tip?
funders all the time. There are a couple in this room, and I call them all the time because they get a second view of the case, right? And I'm not saying funders make wrong decisions. Funders make very good decisions. But ultimately, it's the client's decision. It's who's advising them, and can someone who's an equity holder, who's not a lawyer, drive the decision? That's the question. But second, just so you know, the New York State Bar Association, the ABA, encouraged collection of data in this. That was the resolution before the resolution we won last summer that said, we want data collected, because none of the data shows us it's any better, but there's a lot of data that shows us a lot of risk.
And I'd like to just to clarify, and I was speaking quickly, but to make clear one thing, I wasn't only suggesting that it's the expert witness or settle. What I was suggesting is if the money is not there, or the funder doesn't want to spend the money on the expert witness, it may delay the wheels of justice, because it may delay the trial. And so, because you don't have and I use expert witness as an example, right? It could be an investigation. It could be whatever you want to suggest it is, analysis of the case and so forth. It was just an example. And I used it in both aspects, right? Not only to make a choice to settle, but also to possibly delay the wheels of justice. I'm not saying that's what's going to happen, but I'm saying it's certainly a good possibility.
Sure, all
to
these
consider.
questions.
can I just understand that a bit? The
Yeah.
point, the point appears to be that a funder could turn off the money So let's say you haven't got third-party capital. We're not suggesting, I assume, that law firms could never run out of money. So what happens in that circumstance that's less odious to you than a funder turning off the money when the merits? are
I've
changed?
had that situation. You go to other funders.
Right. So I don't understand. I don't think there's any argument there from the
No,
proponents.
so I think, Adrian, I think the difference is when you're
But there
bound,
may be times when there is no other
Let's
fund.
let Sherry complete her.
when you're bound because you have a business agreement with an individual, then you're bound in essence to their decision. And I would presume that that funder would not necessarily, and maybe I'm wrong, and funders in the room tell me, would not be happy with you if you said, well, if you're not going to pay for it, I'm going to go to somebody else who's not my partner necessarily. Now, maybe that could happen. Maybe that wouldn't happen. It complicates the discussion and the issue. But I think that's where it's different. You're bound in a different way when you're in a partnership agreement and you both have equity in a particular business
Well,
interest.
Well, every responsible funder will have in its funding agreement a provision that prohibits the fund, certainly in common law jurisdictions, prohibits the funder from taking control of a case. Different funders draw the line at different points. We at Benchwark, for example, prohibit ourselves from having anything like a final say on settlement discussions. So I'm sorry, I didn't catch the name of the questioner in the audience who said, you know, might funders not be making a better decision on settlement? Your funder shouldn't be making the decision on settlement. Otherwise, that funder is arguably in breach of Champity rules, depending on the jurisdiction.
Yeah, and I agree with that. And that's the exact problem with ownership, because then they do have control. But here's the
They
thing.
do
we're
not.
I don't understand.
point in
Sorry, I don't
Arizona,
understand why
they
they
do
do.
not.
I don't understand why
It's
they have
not
control
true.
in any
If
more
you're a
relevant sense.
51% owner, you have to say at the end of the day. But here's what we're all missing.
Sure.
We're all missing. You're getting off in all these economic decisions. This is about core values. Do you think if Walmart owned me, I'd be doing pro bono? Rocket Lawyer is already owning law firms. I asked them, are they doing any pro bono? They said zero. Do you think they would be encouraging me to speak in front of my chief judge about improving access to justice? They don't care a dime about that. This is about the core values of our profession. That's why the New York State Bar stands for this. We know that there are risks. We've identified the risks, but it's the core values that we believe in because we're lawyers and we have an independent duty. We abide to a code because we're professionals, and there's no such code for a non-lawyer.
So we're
It's-
going to have a
okay,
quick
hang on,
reaction
just
from
a-
Charlie, and
just-
then
just
we're
a-
going to
just
get
a
a
couple of
question
points.
from
Yeah.
Professor Fitz.
Hang on, just to come back on a couple of points there. It's not a contract of slavery. If you want to do more pro bono work, leave and go and join another firm. But secondly, it comes back to the point, the ethical, no funder could force a lawyer to breach his or her ethics rules. That would be baked into the contract. And even if it worked, I'm pretty sure a lawyer would be released from a contract that required him or her to breach ethics rules. It's like we're chasing ghosts here when we're saying that third parties are
We're
somehow
not
going
talking
to
about
force
litigation funding.
breach
We're
of
talking about
ethics rules.
ownership.
Okay.
It's exactly the
Exactly
same, exactly the same
Well,
in
that's
your
it.
equity.
Adrian, it's-
Debt and
it
equity
is-
are much different.
It is exactly the same in Arizona because the Arizona rules specifically say if you're going to start up an alternative business structure, the lawyers in that firm must always observe the rules of professional responsibility. And the non-lawyers cannot be involved in the day-to-day practice of law and make those decisions or cause the lawyer to breach his or her professional
And
responsibility.
Charlie, a funder in Arizona stole hundreds of millions of dollars from clients in Florida. How did that happen?
And
Okay.
and that can happen with
Okay.
any lawyer.
So
in
no,
any
but
jurisdiction.
let's
Let's-
accept that premise. Let's accept that premise. Can we agree that if the ethical rules applied to third-party funders, as in fact I think they do in most jurisdictions, but if they applied so that no third-party funder would be entitled to require a lawyer to act in such a way as to cause him or her to breach his ethical rules, you'd be happy?
No, because that's what happens in Arizona. It's
No,
still a
no,
problem
no,
because
you're-
there's no way to
you're
enforce
saying that-
it.
wait,
Because
wait.
that person is just a capitalist. They're going to move on to the next best opportunity. And we've seen it in the case the way we saw the Florida bar complaint. But you're
Okay.
arguing with the wrong tree.
Let's get a question from Brian. Thank you.
Thank you, thank you, thank you. I have to admit, Stephen, that I find it quite unrealistic to think that lawyers are not rational economic actors, just like everybody else in society. I don't think we're angels. I don't think we behave differently than every other human being does. I think
I
we are self-interested at the end of the day.
Yeah.
So if you will grant me that for a moment.
I agree.
in order to conclude that the incentives will be worse if we have non-lawyer ownership, I think we need to know something about how the owner and the lawyers are compensated in firms with non-lawyer ownership. Because it seems to me the incentives could be quite similar in non-lawyer ownership. So example one would be the firm still bills by the hour, and some portion of the hourly revenue just goes to the owners. I don't see how the client is treated any differently, even if the owner does have control, because everyone's getting paid by the hour. Another model might be the firm is a contingency firm. So they get a percentage of, and all those percentages go to the owner, and the owner pays the lawyer by the hour. In that situation, the owner's just stepping into the shoes of the contingency fee lawyer. The incentives of the owner are the exact same. The incentives of the lawyer would have been in a pure, in a pure lawyer-owned contingency firm. So I don't quite understand what structure of compensation between the lawyer and the owner you're worried about that leads you to conclude the incentives are going to be worse if we have a non-lawyer owner.
Yeah, actually, you've hit the nail on the head. All that's going on in Arizona and Utah is they're taking the profits out of the legal business and they're putting it in private hands. That's exactly what's going on, right? So why are you doing it? What's the reason to do it? What's the reason to throw up a profession that's worked since the time of the Queen's courts, okay? The only reason to do it in my mind is if you promote access to justice. And that's something I do believe in. I think there are ways to do it. But there are incentive models, for example, the insurance broker model. If you're splitting commissions between a lawyer and an insurance broker, you better believe that client has life insurance, right? If you're splitting commissions between a trust and estates lawyer and a wealth manager, you better believe that they're only going to get stock from that wealth manager, not from the Merrill Lynch office down the street. Those are the incentives that are a problem, and they've been realized in Arizona.
We have another audience question.
Yes, it sounds like, Stephen, you believe that there is a way that all lawyers think and somehow it's
No, I don't.
differentiated
I
from
don't.
the way capitalists think. And I'm trying to figure out what is the one example you have where all lawyers would agree and then they would also disagree with the capitalists. That's one. And then two, why is it not increasing access to justice when you introduce a model where there's more capital coming to the space, which allows more law firms to proliferate and to create an access point at a lower price point for more potential claimants?
So one, I would never say all lawyers think the same. I know we all think so much differently, but I can tell you, when the surveys have been done, New York, California, most recently in Florida, overwhelmingly, lawyers don't want this because we believe in the values of our profession. Now, to go to access to justice, I wish that access to justice was being done in Arizona and Utah. Well, when you talk about the majority of the people being, one, wealth managers, my pro bono clients don't need a wealth manager. Two, personal injury lawyers. Personal injury lawyers have access to all of this capital out here. They don't need non-lawyer ownership, right? What they need is somebody, when they're thrown out of their house, when they're today being, not able to see their own child, or they're being thrown out of the country, not a single non-lawyer owner firm in this country is representing poor people in those cases. And this is Sherry's world.
Let me.
Let's
let
let
me-
Sherry respond because it is her world.
I just wanted to comment on that, a couple different things. So there is one concern that I've raised this before. It hasn't been fleshed out, but it's one we should think about, which is if in fact you're funding to, like you're suggesting, and let's say the funders are interested in providing legal services for free, basically, because that's what we need for access to justice, right? Then there comes into, and I'm interested in this is a question I have, but it's a concern, is how does that impact the funding, the budgeting that's going into legal services, state, federally, and countywide? Because if our governments start to see that they're, okay, this individual or that individual is going to invest, they're going to cut the budgets of those legal services corporations, and potentially those legal services corporations, which by the way, we're already getting cut, but that's for another day, that those legal services corporations are not able to then provide their services. I'm not suggesting it's bad or good. I'm just saying it's a question. The other point I just want to raise, and I raised this when I spoke, and it's an important one, is I think what's missing from this discussion, and to answer a lot of the questions about what people think, because I don't profess to suggest I know what everyone thinks or that everybody thinks the same, is we need more data. We need surveys from these clients who are being served in Utah and Arizona. And we've talked about this. We need that data. Are they being served appropriately in these models? And if they are, okay, then we have something to talk about. If they're not, then we have something to talk about. So let's get that data, right? Let's find that information before we go all the way heads in and down this path.
I agree with that, but I don't think the second question was answered, which is why doesn't more capital spell more access?
Because it's where the capital is going, okay? Raise your hand if any funder wants to invest in the Legal Aid Society of New York. Raise your hand. Do you want to invest in Brooklyn Access to Justice? Raise your hand. See, that's why. It's going right now to where the money will produce returns. And I have nothing problem. I'm a capitalist myself, but it's not going to solve the access to justice problem in our country.
For crying out
You
loud.
can do it in 30 seconds.
The idea that
use
because
investing
you
in
can't
legal aid.
solve all problems, you can't solve any. It's
Yeah,
like,
I was gonna say,
it's a pretty basic logical fallacy.
Okay.
if we want to solve the access to justice problem in this country, lawyers have to be more efficient and more transparent.
I agree.
And that way is going to be achieved by non-lawyer ownership, getting more capital and more relationships with data and.
Thank you, everyone, each and every one of the panelists. Thank you for the audience for your patience with
Thank you.